In 1963, an engineer named Robert Kearns drove through a light rain in Detroit and watched his own windshield wipers annoy him. They had two speeds, slow and fast. In a drizzle, both were wrong. One smeared, the other slapped a dry windshield. So he built a third option, a wiper that paused. He wired it from parts you could buy at any electronics counter, and he timed the pause to the rain. He took it to Ford, the biggest carmaker in the world, and showed them what he had. 6 years later, Ford was selling it. They just weren't paying him for it. Here is the thing that makes this case so strange and so important. Kearns hadn't invented a new part. The transistor existed. The capacitor existed. The resistor existed. Anyone could buy them. What Kearns had done was wire them together in a particular arrangement that did something none of them did alone. It created a controllable, variable delay between wipes. His patent, United States Patent 3351836, filed in 1964, did not claim the transistor. It claimed the combination. And that is the quiet battleground of patent law, whether putting known things together in a new way is an invention, or just assembly. Kearns said it was invention. He had the patent to prove the office agreed. The carmakers would spend decades arguing the opposite. That his wiper was obvious, that any competent engineer would have arrived at it. That you cannot own an idea built from parts everyone already owns. The entire war turned on that single question, not who built it first, but is a clever combination something a person can own. Kearns brought his device to Ford in 1963 under the understanding that they were evaluating it to buy it. They sent his prototype back. They told him, in effect, thanks but no. And then in 1969, intermittent wipers appeared on Ford's Mercury line. Kearns bought one, took it apart, and recognized his own design. He was not a man who let it go. He sued Ford in 1978, and when he saw the same feature spreading across the industry, he sued Chrysler in 1982, and others after. The companies did not deny the wipers worked the way his patent described. Their argument was that the patent should never have been granted. Combine cheap parts, get an obvious result. No invention, no infringement. Kearns' answer was personal and absolute. He did not just want money. He wanted to be recognized as the inventor, and at times he wanted the right to manufacture the wipers himself rather than license them away. The litigation swallowed his life. He represented himself for long stretches, questioning witnesses on the stand after law firms walked away. He spent more than $10 million in legal fees. The case, by his family's account, cost him his marriage and, for a time, his health. In 1990, the Ford case reached a jury. Before it did, Ford offered Kearns $30 million to settle. He turned it down. He was reportedly asking for as much as $395 million, and more than the money, he wanted the verdict. The jury gave him a narrower win. They found that Ford had infringed his patents. The combination was valid, it was his, but that the infringement was not willful. They awarded $5.2 million. Rather than fight another round, Ford agreed to pay $10.2 million. Then came Chrysler. In 1992, a court ordered Chrysler to pay Kearns $18.7 million with interest. Chrysler called the award excessive and appealed. The Federal Circuit let the judgment stand, and in 1995, the United States Supreme Court declined to hear Chrysler's appeal, which made the win final. The Patent Office had been right. The combination was an invention, and the men who said you cannot own an idea built from common parts had just been ordered to pay for one, so Kearns. On paper, decisively, two of the largest companies in America paid him, and the courts confirmed his patents were valid and infringed. But ask what he actually got, and the answer is harder. He never built the manufacturing business he wanted. The money, spread across a case that ran from the late 70s into the mid-90s, was largely consumed by the cost of getting it. The intermittent wiper became standard on nearly every car on Earth, and the man whose name was on the patent spent the prime of his life in courtrooms proving it was his. He had been right the entire time. Being right, it turned out, was the cheap part. Defending it took 17 years and almost everything he had. That is the first lesson of this channel, and it runs underneath every file we will open. A patent is not protection. It is a license to fight, a piece of paper that says you are allowed to spend years and fortunes proving what it already states. Kearns owned the pause between wipes. The law agreed, and it still took 2 decades and 2 appeals to make the world pay for it. Next time a man who invented the laser watched the world build a billion-dollar industry on it and waited 30 years for the patent office to admit he was first.